2 lies employers tell their employees. We're covering one of those today. Many employers tell their employees in order to submit a religious accommodation request, the employee must use the form that the employer has created, an online portal, or an unmonitored email address. Employees who have their religious accommodation requests are denied and then told by their employer that there is no appeal process and that the decision made by the employer is final. These statements are both lies, and we're going to address one of them today. Hello everyone, my name is Joseph Radzwion IV, your trusted attorney with Radzwion Law PLLC, and today we are looking at whether an employee must use an established process by the employer when submitting their religious accommodation request. We will also be looking in a part 2 whether the no appeal attitude of many of these employers is legitimate. And in order to make sure that you don't miss that post, please head on over to our website and subscribe to our blog. We send out a post or an email every Friday. So let's get to it. Lie number 1, my way or the highway attitude. My way or the highway. That's what we'll call it. Employers have continually lied to their employees, taking this, you must submit your religious accommodation request via whatever we say, right? However we want it done, that's the way you as the employee must do it. This is lie number 1, and the law does not provide for that. It does not require an employee to follow the my way or the highway approach set forth by the employer. An employer cannot require an employee to submit their religious accommodation request on a company-specific form, through an online portal, or to a designated email address. You may be wondering, well, if an employer cannot require an employee to submit their religious accommodation requests the way the employer wants, why does the employer lie to the employee and tell them and try and get that employee to submit their request the way the employer wants it done? Well, consent to terms. That's the biggest reason. An employer wants to try and get an employee to consent to terms that help the employer in the long run. But the law is clear. An employee cannot be required to agree to terms in order to assert their legal rights under Title VII. It's not a contract. It's the employee asserting their rights. More on this topic in our post titled Things an Employer Cannot Do, Part 1. The link will be below. So what is required to put an employer on notice of a religious accommodation request? How would the employee follow the law instead of a process in which the employer has set up? Under Michigan law, an employer is deemed to have been put on notice when an employee makes a verbal or written request for an exemption. A notification method may be reasonable and constitutional if employing the method is reasonably certain to inform those affected. The employee is only required to ensure that the method used to provide notice is reasonably certain to inform that employer. Examples may include sending an email to the Human Resource Department or sending a letter via certified mail. It may depend on how your company is structured. You may want to consult a trusted attorney on how to go about that and navigate how to submit your religious accommodation request. If you would like to retain Radzwion Law PLLC as your trusted attorney, please do not hesitate to contact us. We are here to protect you when you need it most, and we will fight for your freedom. Thanks for watching. Here's the obligatory subscribe, comment, and hit the bell notification below. We will see you next time. Thanks for watching.